let's just stick to what we know, yes? Stick to the facts.
Once you've ruled out the impossible, whatever remains, however improbable, must be true.
What does that mean?
Yeah, Dr. Watson actually has a really good point there, Sherlock, because your statement really doesn't mean anything. So here's what it actually says. Once you've ruled out the impossible, whatever else remains, no matter how improbable, must be true. And that's completely illogical and unscientific. And it has had a rather negative effect on the forensic science community and forensic science interpretation. It's called negative corpus. That is, I don't really have evidence for the thing I'm concluding, but I'm saying that there's no evidence for anything else. And so the fact that I have a negative amount of information about other things means I can make this assumption over here. The problem, there are several problems with it, mostly because, well, I mean, you probably don't have any evidence for this either, so it's on par with all the other possible conclusions, right? So you can't just say, for example, and we're going to be talking about fire investigation today, that you have an arson just because you ruled out the other causes, because you don't have a basis for arson either. So you could just say, well, I don't have a basis for arson, so I'm going to assume it's an accident or something of that nature. So that's one, that bias problem is one of them. Another one is that in the real world, as opposed to in a story, there is no such thing as impossible, right? You can't really rule out every other cause because you don't have perfect knowledge about the crime scene or about the situation. And however improbable is, in some respects, a subjective determination relative to impossible. Because what you're really saying is that there are highly statistically unlikely occurrences or possibilities in different kinds of ways of looking at a situation. And you're ruling one possibility to be impossible, and you're ruling the other one to be highly improbable. And you don't really have a basis necessarily to make that difference in statistical claim. And so, however improbable and impossible really don't have a substantive difference in most real world situations. And then this must be true. There's nothing that must be true. Again, you're making a subjective judgment, not a logical one, about what might or might not be the case. So in this episode of Sherlock, there's the question of, well, maybe there really is a deranged hound running around the moors of England. And that, if you want to do that, that's fine in a story. But in real life, in a forensic science interpretation context, you really cannot do that. Let me convince you, hopefully, if you're not already convinced, with a story of a wrongful conviction. This is the Joseph Aw case. Aw owned a bar called JJ's Pub. This is a picture from, September 11th, 2006, when the JJ's caught fire. And this is the fire department's response team, or trying to put out the fire. The main part of the fire was actually around the back of the building, and you can see the back of the building. A lot of the inside was pretty badly damaged, pretty much destroyed in the fire. And so here's the aftermath. One of the key parts of the aftermath I'm going to show you here. Like a lot of bars, there were video games and things like that around, and there was a room where there were a bunch of video games actually in the back of the pub, and it was concluded fairly quickly that the fire had originated in that room, or as they say in fire debris investigation parlance, in that compartment of the in that enclosed area within the pub, and there was pretty intense burning in that place. So there are at least two possibilities for what could have set off the fire. Let's look a little bit more closely. You'll see over here to the left actually is a service panel for the machines, and so and you can sort of see, if you look, there's dangling wires and that kind of thing around the service panel. In this picture. The other theory was based on this hole. So there was a hole in the side of the room, and the idea was that it was arson because that hole was punched out and there was material put in there, and that was set on fire. There was never any accelerant ever found in the fire, or in the fire debris. And so the idea was, I suppose, that they didn't really use an accelerant. They just let some paper or something else that was reasonably flammable on fire in that little fireplace area that was made by punching a hole through the wall, and that's how the fire started. So these were the two main competing theories that police investigators and fire investigators started with right out from the get-go. The investigation was led by the local county sheriff, Marquette County. This was in Wisconsin, and Marquette County Sheriff's Office led the police side of the investigation. They quickly called in the state as well, the state fire marshal. The lead investigator from the county was Chief Deputy Conrath. Conrath is actually now the sheriff of Marquette County, and he admitted it under oath in court later that no one really did a good job on the documentation of the evidence coming out of the important and out of that room, where the fire had originated, which was a key element of the overall investigation that undermined the investigation from the get-go. Conrath made one other mistake here, but it was not just his mistake. It was a mistake that was broader in terms of the investigation, but we'll get to that in a second. So good that he brought in the state fire marshal, because they didn't really have local resources to do a fire debris investigation of the complexity that was required at JJ's Pub. But even the state fire marshal really didn't have the resources, especially when it came to understanding electrical caused fires. So this is exactly what they said. We don't have resources to do that kind of work. We're very reliant on insurance companies providing us with that resource. And if you're not somebody who is involved in law enforcement or forensic science or fire debris investigation, this might be a little shocking to you, that there is a lot of reliance on insurance company money, investigators, and that kind of thing when it comes to fire debris investigation that might end in a criminal charge. And the problem is obvious, right? You have a vested interest as an insurance company in concluding that the fire was arson. And so at that point, you're then saying, well, it's the insured's fault for setting the fire, which of course sets them up for criminal charges, as opposed to the insurance company's responsibility if it's an accidental fire. Now, I am not saying that the insurance company in this case or in any other case deliberately changes the view or interpretation of the fire. I am saying, however, that they are human beings and they have biases like everybody else, and they are going to, especially when the issues are ambiguous, as they often were in the JJ's Pub investigation, they're going to have a tendency to err on the side of the insurance company and a conclusion that of incendiary cause, which is the technical word for arson. So the pub was actually insured by the Mount Morris Mutual Insurance Company, and for I think it was like $200 or so thousand dollars by Joseph Awe, who was the owner of the pub. Now, Mount Morris then brought in a consultant because they too they went on a consultant for both the fire debris investigation more broadly and for the interpretation of that electrical panel to see what was going on there. And that investigator then basically took all of the materials relating to the electrical system out of the building. His name was Korenik. And as you see here, here's the laundry list: wires and conduits, switches, lights, panels, circuit breakers. It did a reasonably thorough job. Korenik is actually, I believe, still active as an electrical engineer specializing in fire investigations. He had done a fair number of fire investigations before this, I assume since this. And so he was reasonably thorough in collecting the evidence. However, the problem being, again, that he worked for the insurance company, not for either the state fire marshal or for the state or for Marquette County Sheriff, and he was compensated by the insurance company, not by the state or the county, which means that when he takes material out of that fire scene, he's not really taking it officially into a official chain of custody, unless he's really following very, very strict protocols in collaboration with them, which was not the case in the Joseph All wrongful conviction. So, as was said later by the court, these investigators interfered with the evidentiary chain of custody, undermined the credibility of all the state's witnesses because they were paid by Mount Morris, and the state failed to comply with statutes as to the designation of independent investigators and compensation of witnesses. It's possible they just weren't aware of all of the conflicts of interest, but I don't think that's the case. It does not appear to have been a claim made by anybody in this case. They just assumed, as part of the routine business, that they were going to use the insurance company's investigators instead of independent investigators in terms of interpretation of the fire. Now, these, again, like I said, these were not fly-by-night, unexperienced investigators. They were people who should have done a reasonable job. And Cornick, actually, when he looked at that panel, found evidence of arcing, of exactly the kinds of patterns you would expect if this was an electrically caused fire. He saw it around the panel. He saw it around some of the connectors to the panel. There was a clear evidence in his notes, in his notes about the case, that he saw arcing. However, whether it was because of bias from who had retained him, or bias from facts of the case, as we'll talk about here in a minute, or whatever reason, his final report didn't mention the arcing. And he said no signs of electrical overheating. Whatever, how does that mean that he is not admitting to the arcing, and he's using a kind of a euphemism around this that says maybe the arcing was insufficient in his view? Maybe very hard to understand what that language means. But he also uses this term, which is a very common term in some of these kinds of forensic science investigations and conclusion language, a reasonable degree of scientific certainty that the cause of the fire at JJ's Pub was not electrical. And so basically saying, hey, it was not an electrical fire. And this is where the negative corpus comes in, because once you've decided that it's not an electrical fire, and all these other individuals were relying on Cornick, then you go back to the whole. You say, the only other place that we can think of where the fire could have occurred is this, no matter how improbable, idea that they punched a hole in the wall and started the fire there. And so that is where the negative corpus came in. And a lot of this was biased by some of the other case information. And so the police had told the fire investigators some basic things that raised questions about Joseph Awe and his intentions that could have led to him wanting to burn down the building. One was a statement that there was a for sale sign out in front of the bar. The other was this perception that the building was overinsured, that it really wasn't worth as much as Awe had insured it for. And also this idea that Awe was in financial trouble, which Awe actually did a reasonable job responding to. Saying, the bar wasn't making me a rich man, but it wasn't, but it was making money. It was not losing money in a way that would make me want to abandon the business, which he had for a number of years. There was another thing that came forward, though, later that really changed the investigation for the state fire marshal and for everyone else. And I'll get to that in a second. But in the end, based on these kinds of innuendo, again, this was really innuendo more than it was evidence. You can call it circumstantial evidence. They really decided to go heavy on the negative corpus. And at this time, negative corpus was still allowed in fire investigation if you had a place where the fire could have been, for the origin of the fire. You had established the place where the fire had started. And they really hadn't done that in this case, truly. They didn't know that the fire started in that hole. They knew the fire started in that compartment, in that area. But they really didn't have a basis to say that the hole was the origin of the fire versus the electrical panel versus another place within that room. But this is how they described it. There's only so many accidental possibilities. One by one, you eliminate that. You look at them, you identify them, you examine them, you determine whether they could have caused a fire, whether they couldn't have. Once you eliminate Each and every one of these then you can refer to this as an incendiary fire. That's how we do it. And so this is a classic statement of negative corpus. This is exactly how countless fire investigations were done in the mid 2000s and dating back into the 90s, 80s, and 70s. This negative corpus idea really almost came directly out of Sherlock Holmes, and it was considered rigorous because it was just so convincing in that English accent, I guess. I don't know, but again, they ignored this idea that they did not have evidence for incendiary origin either, right? So they were looking at all these other things saying, well, we're trying to get at the arson cause, as opposed to saying, well, we really don't have evidence for, which you can argue actually based on the interpretation of the arcing in that electrical panel. We don't have evidence for an electrical cause or an accidental cause or something else like that. And we don't have evidence for an arson either, an incendiary cause. And so we really just have to say inconclusive. Or you could say we've eliminated everything else and it's an accidental cause. Instead, they were biasing themselves toward an arson conclusion by this logic. It really was not putting all the different theories and about the possibilities in the case on the same level. And as a result, they were kind of almost inevitably going to come to an incendiary cause once Korenick had come back and said, well, I just don't think it's an electrical cause. And it's exactly the same as Holmes. Once you've ruled out the impossible, whatever remains, however improbable, must be true. It's the same exact logic. This is how the National Fire Protection Association put it. Investigators should be wary, not way, wary of the trap of circular logic unless there's a reliable evidence to narrow the origin to a particular portion of the room. Every possible ignition source in the compartment of origin should be given consideration as a possible cause. I would have actually put it a different way. I would have said every potential ignition source should be given equal weight. And also, I would re-emphasize this idea of narrowing the origin to a particular portion of the room. In this case, you see how that can be weak, because the idea being like, did they really narrow it down to the whole? They really didn't. And they still applied the negative corpus from that NFPA 921 at this point was still allowing. They actually changed NFPA 921 very soon after this case. Not because of the Joseph Hall case, but because it was recognized that it was not a good way to do interpretation. And this is again how the appeals court eventually ruled about this issue. The evidence adduced at trial, don't you love legalese, was entirely circumstantial, there being no proof of causation or facts placing defendant at the scene of the fire during which initial ignition occurred. Uncontroverted testimony places the defendant 35 miles away from location throughout the day and evening prior to the fire. Yet, so Joseph All was not in the building or anywhere near the building at a time when he could have set that fire in that compartment, in that hole that was theoretically, they don't even know, punched or opened in the wall. So there's just no evidence that he was anywhere nearby. It would have had to have been, at minimum, a conspiracy to do that. He would have had to have an accomplice of some sort. There was never any substantive allegation about him having an accomplice who did this and who would have been in a position to do this. And so they really didn't have that. They said Joseph All set the fire, really, but he was 35 miles away, and therefore really could not have done it. At this point, he had not yet been arrested, and all of the electrical cause and the other investigators had said, we think it's arson, because they really didn't have anything but circumstantial evidence coming into the possibility of arresting him and then putting him on trial. And that changed because of this poster up here. So he had actually been in the Gulf War, and this was given to him, showing him and his buddies in the Gulf War. It had this very special place. You can even see the video games here. In the bar, a place of honor, as you would expect that he would have for something along this. This is his lawyer with what I believe is actually a copy of that map what happened is that Conrath, that chief deputy sheriff, actually had an informant who said that Joseph All had come to him and said, I did deliberately set the fire, and I even pulled that poster out of the bar ahead of time so that I wouldn't lose this thing because it meant so much to me. Again, not clear to me how Joseph Awe and that person would have been communicating at that level and at that level of trust if Awe was the arsonist, and as alleged by the police and by Conrath. Conrath clearly, one of the things that he did here, and the other mistake, was he kind of then went circular back. And we talk about circular reasoning and negative corpus. It encourages you to have the kind of a cycle of bias back and forth. And so there was this circumstantial evidence that kind of influenced the fire investigators to say that it was an incendiary cause or arson. And then Conrath and the other police investigators in this case then took that back over into the police investigation and said, well, how are we going to make the case, right? How are we going to prove that did it? And this informant really was a big deal in that regard. Conrath clearly believed the investigators, the fire investigators, about their conclusion. He actually made a very similar mistake in terms of deference to authority, which in policing, you almost have to have deference to authority to some level, right? Policing, in some respects, is about enforcing the will of the state on the populace and making sure you have public safety. And so you don't attract people into policing who don't have some deference to authority. It can go too far. Conrath, for example, later here in this last few years, there was an incident in Marquette County where a young teenage girl very early during COVID had caught COVID and actually gotten very sick. When she got home, she actually posted on Instagram talking about how happy she was that she had recovered and how scary it was for her to have gotten COVID. And the implication was that she had gotten it on a school trip that she had just come back from. The school administrators were very upset. And again, this was very early in COVID. They were like, this teenager is causing everybody anxiety in the entirety of the county and in the school. And she doesn't know that she even had COVID. And so they actually called up the sheriff's office, and Conrath sent one of his deputies out to her to say to her, you have to take the Instagram down or we're going to have to arrest you. And which is, of course, extraordinarily inappropriate. Again, it was a kind of a deference to authority thing that there's this kind of, that's a kind of bias that you can have, and it can blind you to seeing, well, maybe you're making a mistake here. And as it turns out, the teenage girl and her family went to court, and the court said as much, saying that it was very inappropriate for the sheriff to violate her First Amendment rights by telling her she couldn't have this post up on Instagram, and deferring to the school authorities who just were not clearly managing the issue as well as they should have with respect to COVID. And we see this in the investigation here too, where it's like this circular logic kind of builds on itself, saying, the insurance company has interests, the law enforcement has interests, the fire investigators are experts, and we're just gonna push that through to its logical conclusion. And as a result, All was arrested based on this informant and this poster, as well as the rest of what I've said, for arson in April of 2007. So roughly, 8 months after the original fire. He had this other problem, and that is that his defense was grossly inadequate when it came to interpreting the fire debris and having his own interpretation be able to be put forward. It's very common in wrongful convictions. His primary fire debris expert had very little experience in fire debris analysis, hadn't even read NFPA 921, that document I referred to earlier, which is basically the Bible of fire interpretation, at least here in the United States. The expert had never really investigated an arson fire at all, never took a course in arson investigation, never testified in a criminal case, didn't have access to the electrical panel either. So it's possible the expert might have noticed the arcing and been able to, at least defend all on that basis, but he didn't have access to the electrical panel. And he didn't know, neither the lawyer nor his main expert knew that the state had relied on the insurance company investigators. That was not disclosed to them, which was a serious problem. There was actually another expert who had come in and had looked at some of this material as well, an independent expert, and had actually made very favorable conclusions about the possibility of electrical fire. But the defense lawyer didn't consult with that person or really run things through with the prosecution experts before the trial, relying on a cross-examination approach, which is really inadequate when you're trying to challenge the science in this kind of a case, and didn't use this independent expert who said it was an electrical fire at all, which by itself was a very, very problematic. So, of course, that December, was convicted. He was sentenced to 3 years in prison, 9 years of supervised, basically parole. He didn't go to prison till the following year, as different appeals were pending. And that would have been the end of the story, except for these three individuals. I won't call them the heroes of the story. That's kind of inappropriate, I think. But they are the people who weighed in and brought this case around full circle back down and brought it to some foundation within fire debris analysis. We'll start with Dee Hall. She was an investigative reporter with the Wisconsin State Journal, which is on Madison.com, which is why you see that in some of these bylines from her. Really, really impressive investigative reporter. There are still investigative reporters who make a big difference in cases like this and other important things within the journalistic community. She did an enormously good job on a 4-part series for the Wisconsin State Journal, laying out everything that had happened in the Joseph All case and really bringing some attention to it. And then Mark Sver came in, who is a nationally recognized expert, actually does training in this field of looking at electrical causes of fire, and actually examined the evidence and talked about the fact that the panel itself was kind of sketchy. That's not a reason to say it was an electrical fire per se, but it had the potential, certainly based on the fact how it was constructed and how old it was and how it had degraded to create a fire. But then he also showed that clearly using a technique called arc mapping, that the arcing that was observed and the overheating of a specific connector that caused that arcing clearly was what could have started the fire, at least. So that was a very, very important analysis. And then a gentleman by the name of John Lentini, who has become kind of a legend within the fire investigation community, came in and talked about this in a broader sense, and has actually written some research work, which I'll try to link to in the description, so you can take a look at his paper on this kind of on this case and others like it. And he basically said that the investigators were influenced what is called domain irrelevant information, which is all this stuff about, Joseph All and his financial problems and the poster and things like that. And mentioned that this negative corpus idea really was something that generally was not well accepted anymore in the fire investigation community. And actually that the NFPA 921 had been changed, constituted a new kind of science. That is that there's new evidence in the sense that the scientific knowledge and consensus about negative corpus had changed within fire debris investigation. And this was actually a groundbreaking case for that new science could constitute new evidence. And Lentini certainly pointed that out. So in March of 2013, Marquette County Judge Wright had vacated the conviction. Not long after that, the prosecutors dismissed the case, and eventually Joseph All settled the case against the insurance company, but for an amount that we do not know, but I imagine it was substantial. Even so, you have to say this was a nightmare for Joseph All. Obviously, it took like 6-7 years from the beginning of him losing his business to eventually even having this case settled and having his name cleared. As he said, I'd hate for anyone to go through what I have gone through. So here are these 3 pictures. This was in happier times. I think this is from that poster picture. This is his beg shot, and this is him being relieved that he got his settlement from the insurance company. So quite a lot going on here. And it'd be interesting to know. I don't know Mr. Aw and everything like that, but I'm sure that he's familiar with negative corpus, and it would be interesting to see what he would say about Sherlock Holmes and how logical Sherlock Holmes is and scientific Sherlock Holmes is relative to John Watson. Because in fact, what Watson raised, like what do you even mean, was legitimate. It wasn't just confusion. It's a legitimate question because it is essentially illogical to adopt a negative corpus, a framework. Now, I will say there's one exception to that in terms of developing theories. So if you want to develop an alternative theory about something, it's reasonable to go through a negative corpus approach. Say, what other possibilities are there? Is there a new hypothesis I haven't thought of? In that case, negative corpus can be very valuable. But using negative corpus to then come to a conclusion is quite inappropriate. And Mr. Aw knows that as well as anybody. And I hope you know it as well as anybody now, too. So that's the Joseph Aw case. That's why Sherlock Holmes is a public menace. I hope you like and subscribe and look at some of the other material and take advantage of some of the other links that I put in the description. Thank you for listening today.